When my wife Eleanor passed away, I expected grief. What I didn't expect was betrayal from my own stepson. He tried to erase me, my rights, and my future. But in the courtroom, the truth destroyed him instead. My stepson tried to steal my late wife's inheritance by having me declared mentally incompetent. He had no idea I'd been 3 steps ahead the entire time. What happened at the competency hearing destroyed his scheme and his reputation forever. I'm Henry Falk, and after 40 years practicing law in Charleston, South Carolina, I thought I'd seen every kind of family betrayal imaginable. Corporate embezzlement, sibling rivalries over property, children fighting over their parents' estates while the bodies were still warm. But nothing in 4 decades of courtroom experience prepared me for what my own stepson Marcus attempted after my beloved wife Eleanor passed away last spring. This story isn't just about greed or legal manipulation, though both play starring roles. It's about how patience, preparation, and a lifetime of understanding human nature can turn the tables on someone who made the fatal mistake of underestimating a grieving widower. Marcus thought he was dealing with a confused old man. He had no idea he was walking into a trap that had been set 3 years in advance. Eleanor and I had been married for 12 wonderful years when pancreatic cancer took her from us in March. She was 68, I was 71, and we'd built a beautiful life together in her family's historic Victorian home on Rainbow Row. The house had been in Eleanor's family for 4 generations, purchased by her great-grandfather in 1923 when he made his fortune in the cotton trade. Eleanor had inherited not just the house, but a substantial trust fund that had grown considerably over the decades through careful investment and compound interest. When we married in 2011, she insisted on keeping her assets separate, which I respected completely. Her money, her choice, her family legacy to protect or distribute as she saw fit. I had my own retirement savings from my law practice, and we lived comfortably without touching her principal. Marcus was Eleanor's son from her first marriage to Robert Whitman, a charming but irresponsible man who died in a motorcycle accident when Marcus was 12. The boy had never quite recovered from losing his father so young, and Eleanor blamed herself for not providing the stability he'd needed during those crucial teenage years. Her guilt made her overly generous with financial support that probably did more harm than good. At 45, Marcus was divorced twice, worked sporadically in real estate when he could avoid his gambling habit long enough to focus on business, and lived in a perpetual state of financial crisis that Eleanor consistently rescued him from. During our 12 years of marriage, she'd sent him monthly checks totaling over $400, always hoping this would be the time he'd finally get his life together and stop needing her help. Our relationship had always been complicated, to put it diplomatically. Marcus resented my presence in his mother's life, not out of protective love, but because he saw me as competition for her attention and resources. He'd been the sole beneficiary of her previous will, and my marriage to Eleanor had introduced uncertainty into his financial expectations. He never said it directly, but his hostility was obvious during family gatherings. The first sign of serious trouble came during Eleanor's funeral service at St. Philip's Episcopal Church. While friends and family shared memories of her kindness and community involvement, Marcus spent more time on his phone than paying respects to his mother. I caught him in hushed conversations with people I didn't recognize, stepping outside during the eulogy to take calls that apparently couldn't wait until after we buried his mother. Before we dive deeper into this incredible story of how decades of legal experience trumped amateur manipulation, please hit subscribe if you believe that wisdom and preparation deserve respect, not exploitation. Your support helps us share more stories of people who refuse to be victims of family greed disguised as concern. Now, let's see how Marcus's elaborate scheme completely backfired in ways he never saw coming. 3 days after we buried Eleanor in Magnolia Cemetery, Marcus appeared at my front door with a man in an expensive charcoal suit who introduced himself as attorney Bradley Morrison. I recognized the name immediately from billboard advertisements around Charleston and television commercials during daytime talk shows. Morrison specialized in contested estates, elder law, and what he euphemistically called family asset protection. The kind of lawyer whose practice thrived on family dysfunction and inheritance disputes. His reputation in the Charleston legal community was mixed at best. Competent enough to win cases, but not particularly scrupulous about the methods he employed or the family relationships he destroyed in pursuit of billable hours. Seeing him on my doorstep with Marcus felt like watching vultures circle overhead. I invited them in for coffee, maintaining the civilized facade that years of legal practice had taught me. Eleanor's antique dining room, with its hand-carved mahogany table and crystal chandelier, seemed like an inappropriate setting for what was obviously going to be an unpleasant conversation. But hospitality has its own power, and I wanted them comfortable enough to reveal their true intentions. "Henry," Marcus began, his voice carrying artificial sympathy that made my skin crawl. "We need to discuss Mom's estate and your situation." The deliberate pause before situation was loaded with implication. Attorney Morrison opened his leather briefcase and spread documents across Eleanor's table with the practiced efficiency of someone who'd conducted this exact presentation dozens of times before. Morrison explained that Marcus was deeply concerned about my mental capacity to manage Eleanor's substantial estate. According to their carefully constructed narrative, I'd been showing signs of confusion, memory problems, and poor judgment that made me unsuitable as executor of her will. They'd prepared a petition for guardianship that would transfer control of Eleanor's assets to Marcus as her closest blood relative and most concerned family member. I listened quietly while they outlined their case, my expression carefully neutral despite the rage building inside me like steam in a pressure cooker. They cited specific instances of alleged confusion, forgetting appointments with Eleanor's doctors, repeating conversations from previous days, difficulty managing our household finances, and what they termed inappropriate emotional responses to Eleanor's death. Each example was either completely fabricated or deliberately misinterpreted normal behavior that any grieving 71-year-old might exhibit. The forgotten appointment was actually rescheduled by the doctor's office due to an emergency. The repeated conversations were me processing grief by talking through memories with Eleanor's friends. The financial difficulties involved temporary confusion about Eleanor's complex investment accounts, not cognitive decline. "We're not trying to hurt you, Henry," Marcus said with the kind of false sincerity that politicians use when announcing tax increases. "This is about protecting Mom's legacy and making sure her assets are handled by someone with the sharp business instincts this kind of wealth requires. You're getting older, and let's be honest, your mental clarity might be diminishing with age and grief." His condescending tone revealed the contempt he'd been hiding throughout our relationship. In his mind, I was already defeated. Just another confused elderly man who needed younger relatives to make important decisions. He had no idea that I'd been anticipating this exact conversation for 3 years, ever since Eleanor first expressed concerns about his escalating gambling debts. Morrison's petition was a masterpiece of legal manipulation, requesting a full competency hearing where court-appointed psychiatrists would evaluate my mental state through comprehensive testing and interviews. If they found evidence of cognitive decline, dementia, or inability to manage complex financial matters, Marcus would become guardian of Eleanor's estate, effectively inheriting everything while I remained in the house as his dependent. The legal maneuvering was sophisticated and ruthless, clearly the work of someone who specialized in these types of family asset transfers. Morrison had researched similar cases and knew exactly which psychological tests would be administered, which questions would be asked, and how to prepare Marcus's testimony to maximum effect. This wasn't amateur hour. What neither Marcus nor Morrison knew was that Eleanor and I had anticipated this exact scenario 3 years earlier. During one of Marcus's particularly expensive gambling binges in 2020, Eleanor had confided her growing concerns about his behavior and his increasingly desperate requests for larger financial support. We'd consulted with my former law partner Robert Chen about protecting her assets from potential future challenges. Eleanor had been a brilliant woman with a master's degree in psychology from the College of Charleston. She understood human behavior, particularly her son's character, better than Marcus realized. Her love for him was genuine, but not blind. She recognized his weaknesses and predicted his likely responses to various situations with disturbing accuracy. During our estate planning sessions with Robert, Eleanor had revised her will multiple times, each version containing increasingly sophisticated safeguards against contested inheritance claims. She'd studied landmark cases involving competency challenges and worked with Robert to craft language that would survive legal scrutiny while protecting her intentions from manipulation. The final version of Eleanor's will, executed just 6 months before her death, contained provisions that would surprise everyone involved in this competency hearing. But Eleanor's planning went far beyond legal documents. She'd been documenting my mental acuity, our financial management decisions, and Marcus's behavior patterns with the thoroughness of someone building a legal case. I agreed to the psychiatric evaluation with what appeared to be resigned acceptance, playing the role of a grieving widower who was too overwhelmed to fight his stepson's reasonable concerns. Marcus and Morrison exchanged satisfied glances across Eleanor's dining table, clearly believing their intimidation tactics had worked perfectly. They scheduled the competency hearing for 6 weeks later, giving them time to gather additional evidence while I supposedly struggled with grief and confusion. The 6 weeks before the hearing were the most challenging acting performance of my life. I had to play the role of a declining elderly man just convincingly enough to maintain Marcus's confidence without actually appearing incompetent to people who mattered. It was a delicate balance that required careful calibration of every interaction. My longtime physician, Dr. Sarah Williams, understood the situation immediately when I explained Marcus's scheme. Sarah had been Eleanor's doctor too, and she'd witnessed firsthand the emotional and financial toll that Marcus's problems had taken on my wife over the years. She agreed to help document my actual cognitive state while maintaining the necessary illusion for Marcus's benefit. Marcus began visiting the house frequently during this period, always bringing his smartphone to record conversations where I appeared confused or forgetful about Eleanor's arrangements. He'd ask leading questions about financial details, insurance policies, and investment accounts, then act concerned when I gave vague or contradictory responses that I'd carefully rehearsed. His performance as a caring stepson worried about my welfare was almost believable if you didn't know about his 200-0 gambling debt to some very unpleasant people who weren't interested in payment plans or excuses. Marcus needed Eleanor's inheritance immediately, not just for lifestyle maintenance, but for basic survival. The private investigator Eleanor had hired in 2021, Thomas Burke, continued monitoring Marcus's activities throughout this period. The documentation he gathered would prove crucial during the hearing, but Marcus remained completely unaware that his movements, financial transactions, and associations were being carefully tracked and recorded. 2 weeks before the hearing, Marcus brought his current girlfriend, Crystal, to the house, ostensibly for dinner, but actually to witness my supposed confusion firsthand. Crystal was a cocktail waitress from the casino where Marcus did most of his gambling, and their relationship was based more on mutual convenience than genuine affection. She needed someone to pay her rent, and he needed company that didn't judge his financial irresponsibility. During that dinner, I played my role perfectly, asking Crystal the same questions multiple times, appearing confused about what we'd eaten the previous evening, and struggling to remember her name despite meeting her twice before. Marcus documented everything on his phone, building what he believed was compelling evidence of cognitive decline. The competency hearing took place on a gray April morning in Judge Patricia Hartwell's courtroom in the Charleston County Courthouse. Judge Hartwell had a reputation for thorough preparation and zero tolerance for legal games, which made her courtroom the wrong place for amateur manipulation attempts. Her 25 years on the bench had given her finely tuned instincts for detecting deception. Marcus arrived with Morrison and 2 additional attorneys from his firm, suggesting they viewed this as a high-stakes case worth significant investment. Their confidence was palpable as they arranged documents and prepared exhibits that would supposedly prove my incompetence. I appeared with Robert Chen, my trusted colleague of 30 years, who'd agreed to represent me despite his semi-retirement from active practice. The courtroom was nearly empty except for court personnel and a few observers. Marcus had brought his ex-wife Sandra as a witness, along with Crystal. whose testimony would focus on instances where I'd appeared confused during recent family gatherings or phone conversations. Their preparation was thorough, suggesting months of advanced planning. Dr. Patricia Reynolds, the court-appointed psychiatrist, presented her evaluation first. She'd spent 2 hours with me the previous week at the courthouse, conducting cognitive tests, mental status examinations, and detailed interviews about my background and current functioning. Her report was thorough and professionally written, noting some mild memory inconsistencies that might be expected in someone experiencing recent grief. However, Dr. Reynolds found no evidence of significant cognitive impairment, dementia, or inability to manage complex financial affairs. Her testing had revealed normal cognitive function for someone of my age and education level, with memory performance actually above average in several categories. This wasn't what Morrison had expected to hear. Morrison's cross-examination of Dr. Reynolds was aggressive and detailed, clearly the work of someone who'd done his homework on psychological testing procedures. He questioned her methodology, suggested that 2 hours wasn't sufficient for proper evaluation of someone with potentially mild dementia, and implied that I might have been having an unusually good day that didn't reflect my typical mental state. "Dr. Reynolds," Morrison asked, his voice carrying the kind of practiced skepticism that juries often find persuasive, "isn't it true that patients in early stages of dementia can appear completely normal during brief interactions, especially when they're motivated to perform well during testing?" His question was designed to undermine her professional assessment while planting seeds of doubt about my actual condition. Dr. Reynolds held her ground professionally, explaining that her evaluation had included multiple assessment tools specifically designed to detect mild cognitive impairment and early dementia. Her testing battery was comprehensive and current, incorporating the latest research on age-related cognitive changes and psychiatric conditions affecting elderly adults. Marcus took the witness stand next, and his performance was worthy of community theater. He described his concerns about my welfare and his mother's legacy with practiced emotion, occasionally pausing to wipe his eyes or take steadying breaths. His testimony about phone conversations, where I'd repeated myself, forgotten appointments, and seemed confused about household finances, was delivered with convincing sincerity. "Your Honor," Marcus said, his voice breaking slightly in exactly the right places, "my stepfather is a good man who's always been kind to me and my mother, but he's not the sharp attorney he used to be. Mom's estate is incredibly complex, with multiple investment accounts, trust arrangements, and charitable commitments that require careful management and business expertise." He continued with growing emotion, "I'm worried that Henry's declining abilities could result in significant financial losses that would dishonor my mother's memory and waste resources she intended for meaningful purposes. I don't want to hurt him, but I have a responsibility to protect what Mom worked so hard to build." Sandra's testimony supported Marcus's narrative with specific examples from recent holiday gatherings where I'd seemed absent-minded, confused, or overwhelmed by simple decisions. She described Christmas dinner where I'd allegedly asked the same question about Eleanor's condition multiple times, forgetting that we'd already discussed her illness and prognosis. Crystal added her observations from recent months, noting that I'd appeared increasingly dependent on Marcus for help with basic tasks like operating Eleanor's television remote or understanding insurance correspondence. Her testimony was brief but effective, painting a picture of gradual decline that concerned family members were struggling to address sensitively. Their coordination was impressive, suggesting extensive preparation and rehearsal. Each witness built on the previous testimony, creating a seemingly coherent narrative about my declining capacity that might have been persuasive to someone who didn't know the full story. Morrison was clearly experienced in orchestrating these types of presentations. When Robert Chen rose for his opening statement, the atmosphere in the courtroom shifted subtly in ways that only experienced attorneys would notice. Robert had been practicing law in Charleston for 45 years, and Judge Hartwell knew his reputation for meticulous preparation and absolute courtroom integrity. His presence suggested this case might be considerably more complex than it initially appeared. "Your Honor," Robert began, his voice carrying the quiet authority that comes from decades of successful practice. This case isn't about an elderly man's declining capacity or a family's reasonable concerns about estate management. This is about a calculated attempt to steal an inheritance through legal manipulation, perjured testimony, and fraud. We're here to expose a conspiracy that insults both this court's intelligence and the memory of Eleanor Whitman. Morrison objected immediately, jumping to his feet with protests about inflammatory language and prejudicial statements designed to bias the court against his client's legitimate concerns. Judge Hartwell sustained the objection, but allowed Robert to continue with more measured language. The damage was done, however, and everyone in the courtroom now understood this would be more than a routine competency evaluation. Robert called me as his first witness, and I took the stand with the professional composure I'd maintained throughout 40 years of legal practice. My testimony was clear, detailed, and completely lucid as I recounted Eleanor's estate planning process, my involvement in managing her investments during our marriage, and my current mental state and capabilities. I explained the complexity of Eleanor's financial arrangements in detail, demonstrating comprehensive understanding of her investment portfolio, tax implications of various estate planning strategies, and specific provisions she'd made for charitable giving. My responses were precise and well organized, contradicting every claim Morrison had made about cognitive decline. "Mr. Falk," Robert asked, setting up the question that would begin destroying Marcus's entire scheme, "are you aware of any specific provisions in your late wife's will regarding potential competency challenges or inheritance disputes?" This question was the turning point that would expose the full scope of Eleanor's advanced planning. Morrison objected frantically, sensing that something dangerous was approaching, but Judge Hartwell overruled him and instructed me to answer. The courtroom fell silent as everyone waited for my response, unaware that Eleanor's ghost was about to speak through carefully crafted legal language. "Yes, Your Honor," I replied with calm precision that cut through the tension like a scalpel. Eleanor anticipated exactly this situation. Her will includes a comprehensive forfeiture provision stating that any heir who challenges the estate's administration, questions my competency as executor, or attempts to have me removed through legal proceedings, would forfeit their inheritance entirely. By filing this petition, Marcus has just disqualified himself from receiving any portion of his mother's assets. The silence that followed was deafening. Marcus's face drained of color as the implications registered with devastating clarity. Morrison shuffled through documents frantically, clearly unaware of this provision despite what should have been thorough preparation. Judge Hartwell leaned forward with professional interest, requesting to see the will immediately. Robert presented the certified copy of Eleanor's final will and testament, directing attention to Section 12, subsection C, which stated in unambiguous language, "Any beneficiary named in this will who contests its provisions, challenges the mental competency of my husband Henry Falk, attempts to remove him as executor, or takes any legal action designed to alter the administration of this estate, shall forfeit any and all bequests, and shall be treated as having predeceased me for all purposes of inheritance." The provision was ironclad and unambiguous, drafted by Eleanor's attorney with language specifically designed to survive any legal challenge. She had anticipated exactly the scenario playing out in Judge Hartwell's courtroom, and her planning had turned Marcus's greed into the very mechanism of his own disinheritance. But Eleanor's foresight extended far beyond legal documents. Robert called Dr. Williams as our next witness, and she testified about my excellent cognitive health based on comprehensive medical testing she'd conducted at my request throughout the previous year. Her records showed no signs of mental decline, dementia, or cognitive impairment of any kind. Dr. Williams had administered the same psychological tests that Dr. Reynolds used, but over multiple sessions, spanning several months. Her documentation showed consistent high performance across all cognitive domains, with scores that would be impressive for someone of any age. The medical evidence contradicted every claim Marcus and Morrison had made about my mental condition. "Dr. Williams," Robert asked, "in your professional medical opinion, does Mr. Falk have the mental capacity to manage a complex estate involving multiple investment accounts, trust arrangements, and charitable commitments?" Her answer was unequivocal and delivered with the authority of 30 years in practice. "Absolutely. Without question," Dr. Williams stated firmly. "Mr. Falk's cognitive function is not only normal, but actually exceptional for someone of his age. He's sharp, well-organized, emotionally stable, and completely capable of handling sophisticated financial matters. Any suggestion otherwise would be medically unfounded." The next witness was Eleanor's previous attorney, Margaret Foster, who'd worked with Eleanor on earlier versions of her will before referring her to Robert for more specialized estate planning. Margaret testified about Eleanor's specific concerns regarding Marcus's gambling problems and her detailed instructions about protecting the estate from potential inheritance challenges. Margaret revealed that Eleanor had been planning this defense for over 3 years, ever since Marcus's gambling losses had reached crisis levels in 2020. She'd consulted multiple attorneys, researched similar cases, and crafted her estate plan with the specific goal of preventing family manipulation while ensuring her charitable intentions would be fulfilled regardless of future disputes. Mrs. Whitman was extremely concerned about her son's gambling addiction and financial irresponsibility, Margaret testified. She loved him deeply, but recognized that leaving him large sums of money would enable destructive behavior rather than helping him build a stable life. Her estate planning reflected both love and wisdom. Margaret also revealed that Eleanor had hired private investigator Thomas Burke to document Marcus's gambling activities, debt situation, and lifestyle expenses. The investigation had uncovered evidence that Marcus owed nearly $200,000 to various creditors, including some individuals who weren't likely to accept payment plans or negotiate extended terms. Thomas Burke took the witness stand with a thick folder of documentation that painted a devastating picture of Marcus's true financial situation. Photographs showed Marcus had various casinos throughout South Carolina and Georgia. Credit card records proved substantial gambling losses, and witness statements confirmed his desperate need for immediate cash infusion. Burke's investigation had revealed that Marcus's competency challenge wasn't motivated by concern for my welfare or Eleanor's legacy. It was about his survival. The people he owed money to weren't the type to accept excuses indefinitely, and his inheritance represented his only hope of avoiding serious consequences for his unpaid debts. The private investigator had also documented Marcus's attempts to research competency challenges through internet searches and consultations with various attorneys before settling on Morrison's services. His planning had begun within days of Eleanor's diagnosis, suggesting that he'd been calculating inheritance scenarios while his mother was still alive and fighting cancer. Morrison's attempts to object to Burke's testimony were consistently overruled as Judge Hartwell allowed the full scope of Eleanor's planning to be revealed. Each witness and document painted a clearer picture of a woman who'd understood her son's character with painful clarity and taken comprehensive steps to protect her legacy from his predictable behavior. Robert's final witness was Eleanor herself, presented through a videotape statement she'd recorded 6 months before her death. The recording was devastating to Marcus's case, showing a sharp, articulate woman explaining exactly why she'd included the forfeiture provision in her will, and expressing complete confidence in my abilities as executor. "Marcus has been irresponsible with money his entire adult life," Eleanor said on the recording, her voice clear and strong despite the illness that was already beginning to affect her health. "I've enabled this behavior for years, sending him monthly checks that disappeared into slot machines and poker games. I love him, but I won't continue enabling his addiction by making him wealthy enough to destroy himself completely." The recording continued with Eleanor's detailed explanation of my mental sharpness, our collaborative approach to financial planning, and her specific instructions about charitable donations that would fulfill her philanthropic goals while providing tax advantages for the estate. Her testament to my character and capabilities was unambiguous and professionally compelling. If Marcus challenges this will or attempts to remove Henry as executor, Eleanor continued from beyond the grave, he'll be proving that he values money more than family, gambling more than responsibility, and immediate gratification more than long-term stability. In that case, He doesn't deserve our family's legacy, and the money will serve better purposes through charitable giving." Marcus sat frozen at the defense table, watching his mother explain with painful clarity why she'd anticipated and prevented his exact course of action. The woman he'd underestimated, dismissed as overly emotional and easily manipulated, had outmaneuvered him completely. Her love had included the wisdom to say no to destructive behavior. Eleanor's recording also addressed the specific instances of alleged confusion that Marcus had cited in his petition. She explained that grief affects people differently, that processing loss involves repetitive conversations and temporary disorganization, and that these normal responses to bereavement shouldn't be misinterpreted as cognitive decline or incompetence. Judge Hartwell's ruling was swift, comprehensive, and devastating to Marcus's case. She found no evidence of cognitive impairment that would justify removing me as executor, noting that Dr. Reynolds's evaluation had actually contradicted the petitioner's claims rather than supporting them. More importantly, she ruled that Marcus's competency challenge had clearly triggered the forfeiture provision in Eleanor's will. The evidence presented today reveals a sophisticated estate plan designed by a loving but realistic mother who understood her son's character and anticipated his likely behavior, Judge Hartwell stated from the bench. Mrs. Whitman's forfeiture provision was properly executed, clearly written, and specifically designed to address the exact circumstances we've witnessed in this courtroom. The judge also ordered Marcus to pay court costs and attorney fees for both sides, adding financial insult to his already devastating loss. His desperate gamble to steal Eleanor's inheritance had cost him not only his mother's legacy, but thousands of dollars in legal expenses he couldn't afford to pay his existing creditors, much less additional attorney fees. Furthermore, Judge Hartwell continued, her voice carrying the weight of judicial authority, the court finds that this petition was frivolous and filed in bad faith. The petitioner's true motivation was clearly financial desperation, rather than genuine concern for the alleged incompetent person's welfare or estate management. Morrison attempted damage control by claiming they'd been unaware of the forfeiture provision and suggesting that their challenge had been based on reasonable concerns about my mental state. Judge Hartwell wasn't sympathetic to their claims of ignorance or good faith efforts. Competent legal representation requires thorough document review and comprehensive preparation, she stated firmly. This forfeiture provision was clearly written, properly executed, and specifically designed to address inheritance challenges. Your failure to identify this provision before filing reflects either inadequate preparation or willful ignorance, neither of which excuses the resulting waste of judicial resources. The aftermath of the hearing was swift and decisive in ways that extended far beyond the courtroom. Marcus's portion of Eleanor's estate, originally worth approximately $800,000, was redistributed according to the will's alternate provisions. The money went to Eleanor's favorite charities, including the Charleston Animal Society, the Literacy Alliance of Charleston, and the Coastal Community Foundation. Marcus left the courthouse in stunned silence, his gambling creditors now facing the reality that their expected payday would never materialize. The people he owed money to weren't known for accepting disappointment gracefully, and his financial problems were about to become significantly more serious than legal embarrassment. Morrison's reputation in Charleston's legal community suffered considerable damage from the public failure and judicial criticism. His aggressive tactics had been exposed as inadequately researched and ultimately counterproductive. And word spread quickly through the professional network about his firm's humiliating defeat in what should have been a routine competency case. The story of Eleanor's strategic planning became legendary among Charleston's estate planning attorneys, who began using her will as an example of sophisticated inheritance protection. Law schools across South Carolina now include her forfeiture provision in coursework about anticipating and preventing family manipulation of estate administration. Eleanor's charitable contributions continued through the estate distributions, supporting causes she'd cared about throughout her life. The Charleston Animal Society received funding for a new adoption wing dedicated to her memory, while the Literacy Alliance expanded services to underserved communities throughout the Lowcountry region. The most satisfying aspect of the hearing's outcome wasn't Marcus's financial loss or public embarrassment, It was the complete vindication of Eleanor's judgment about his character and the validation of her decision to prioritize charitable giving over enabling destructive behavior. Her love had included the courage to say no to someone she cared about deeply. 3 months after the hearing, I received a desperate phone call from Marcus. His gambling debts had reached critical levels. His creditors were demanding immediate payment, and some were making threats that extended beyond financial consequences. He begged me to find a way around the forfeiture provision, claiming it was unfair, and asking for family mercy that he'd never shown Eleanor during her illness. I listened to his pleas with the same neutral expression I'd maintained during his competency challenge. When he finished his emotional appeal, I reminded him that he'd spent weeks recording our conversations, documenting what he claimed was evidence of my mental decline. Those recordings were now part of the court record, preserving his calculated deception for posterity. "Marcus," I said with the calm precision that had served me well throughout my legal career, "your mother spent 3 years planning for exactly this conversation. She knew you'd eventually ask for forgiveness after your schemes failed. She also knew that giving you access to large sums of money would only enable the gambling addiction that's destroying your life." His final attempt at emotional manipulation involved claiming that Eleanor would have wanted family forgiveness to override legal technicalities, that her love would have included second chances even after betrayal. But Eleanor's videotaped statement had addressed this possibility directly, explaining that true love sometimes required tough consequences rather than endless enabling of destructive behavior. The house that Eleanor had inherited from her grandmother remained my home, filled with memories of our happy marriage and evidence of her brilliant strategic mind. Every room contained reminders of the woman who'd protected her legacy through careful planning and clear-eyed assessment of human nature, including her own son's character flaws. Eleanor's charitable legacy expanded beyond her original intentions as the forfeited inheritance created additional resources for community organizations. Her estate planning had turned Marcus's greed into increased funding for literacy programs, animal welfare, and community development projects that would benefit Charleston for generations. Marcus's attempts to rebuild his life after the hearing were complicated by his gambling reputation and the public nature of his failed inheritance challenge. Real estate clients were reluctant to work with someone who'd attempted to steal from family members, and his professional credibility never fully recovered from the courthouse humiliation. The private investigator's documentation of Marcus's gambling activities became part of the public record through the court proceedings, making it impossible for him to hide his addiction from future employers, romantic partners, or business associates. His mother's final gift had included ensuring his problems couldn't remain hidden indefinitely. Robert Chen's representation during the hearing was the final major case of his distinguished 45-year career, and he considered it one of his most satisfying victories. Eleanor orchestrated this defense better than any attorney could have planned, he told me during our celebration dinner afterward. She understood human psychology and legal strategy in ways that impressed even experienced practitioners. The competency evaluation that Marcus had intended as my destruction became instead a comprehensive validation of my mental acuity and professional capabilities. Dr. Reynolds' report became part of my permanent medical record, documenting cognitive function that exceeded normal expectations for someone of any age, much less a 71-year-old widower. 5 years later, I continue managing Eleanor's estate with the same careful attention she'd trusted me to provide. The investment portfolio has grown substantially under conservative management, creating additional resources for the charitable organizations she'd wanted to support. Her legacy extends far beyond our family drama, to touch hundreds of lives through education, animal welfare, and community development. The competency challenge that Marcus thought would make him instantly wealthy instead became the mechanism of his complete disinheritance. Eleanor's foresight had turned his greed against itself, proving that careful planning and accurate assessment of human nature could defeat even sophisticated legal manipulation when properly executed. Marcus eventually filed for bankruptcy protection, unable to pay his gambling debts, legal expenses from the failed hearing, or basic living expenses without Eleanor's monthly support. His creditors received minimal compensation through asset liquidation, and his reputation in Charleston was permanently damaged by his attempted theft of family inheritance. The bankruptcy proceedings revealed the full extent of Marcus's financial irresponsibility, with gambling losses totaling over $400,000 during the 3 years before Eleanor's death. Her monthly checks had been funding his addiction rather than helping him achieve stability, validating her decision to break the cycle of enabling through estate planning rather than emotional appeals. Today, when young attorneys consult me about complex estate planning challenges, I share Eleanor's story as an example of how wisdom and preparation can protect families from their own worst impulses. Her will remains a masterpiece of anticipatory law that continues to inspire sophisticated inheritance strategies designed to prevent manipulation and family dysfunction. The most important lesson from this experience isn't about legal strategy or inheritance protection techniques. It's about the power of really knowing the people in your life, understanding their true motivations and character flaws, and preparing for their predictable behavior patterns. Eleanor's love for Marcus included accepting the painful reality of who he was rather than who she wished he could become. At 76, I remain sharp, healthy, and deeply grateful for the 12 years I shared with a remarkable woman who taught me that genuine love sometimes requires saying no to people you care about deeply. Eleanor's final gift wasn't just financial security or legal vindication. It was the profound satisfaction of watching justice prevail over manipulation through careful preparation and accurate assessment of human nature. The decorated envelope that Marcus probably never prepared couldn't have contained anything more devastating than what his mother had already written into her will years before his scheme began. Her legacy was protection rather than punishment, designed to save him from consequences that would have ultimately destroyed him anyway, while ensuring her charitable intentions would survive family greed. 6 months after the hearing, I received a letter from the Charleston Animal Society thanking me for Eleanor's bequest and describing the new adoption facility that would bear her name. The director included photographs of rescued dogs and cats who'd found homes through programs funded by the inheritance Marcus had tried to steal. Eleanor's money was serving purposes far more meaningful than enabling gambling addiction. The Literacy Alliance sent similar updates about expanded reading programs in low-income neighborhoods, adult education classes for people seeking better employment opportunities, and children's book distribution initiatives that would have made Eleanor smile with satisfaction. Her charitable legacy was touching hundreds of lives in ways that validated her decision to prioritize community benefit over family enabling. Dr. Williams continued monitoring my health with particular attention to cognitive function, creating a comprehensive medical record that would protect against any future competency challenges. Her documentation showed not only normal aging but actually improved mental health as the stress of family conflict was resolved through legal proceedings. "Henry," she told me during one of our regular appointments, "grief and family stress had been affecting your sleep, appetite, and overall well-being more than you realized. Since the hearing, your physical health has improved dramatically. Justice really can be therapeutic when administered properly." The house on Rainbow Row became a peaceful sanctuary where I could process Eleanor's death without the additional burden of defending myself against family manipulation. The Victorian architecture she'd loved, the antique furnishings she'd carefully collected, and the gardens she'd tended all remained as monuments to a woman who'd protected her legacy through intelligence rather than sentiment. Marcus's bankruptcy attorney contacted me once, exploring whether the forfeiture provision might be challenged on grounds of undue influence or mental incapacity. I referred him to Robert Chen, who explained politely but firmly that Eleanor's videotape statement, medical records, and 3-year planning timeline made any such challenge legally frivolous and potentially subject to sanctions. The attorney withdrew his inquiry immediately, recognizing that pursuing the matter would only result in additional legal fees that Marcus couldn't pay while generating more negative publicity about his attempted inheritance theft. Eleanor's planning had anticipated even this possibility, creating multiple layers of protection that made challenges both expensive and futile. 2 years after the hearing, Marcus left Charleston permanently, unable to rebuild his reputation or find stable employment in a city where his courthouse humiliation had become local legend. The real estate community was small and tightly connected, and potential clients weren't comfortable working with someone who'd tried to steal from his own family. His departure felt like the final chapter in Eleanor's story, proof that consequences for betrayal could extend far beyond immediate financial loss. The gambling addiction that had motivated his scheme remained untreated, and his problems would likely continue wherever he relocated, but at least Eleanor's legacy was safe from future manipulation attempts. The competency hearing had attracted attention from local news media, and the story of Eleanor's strategic estate planning was featured in Charleston's legal publication as an example of sophisticated inheritance protection. The article included quotes from estate planning attorneys praising her foresight and recommending similar provisions for clients with problematic family members. Judge Hartwell's written opinion in the case became part of South Carolina legal precedent, establishing clearer guidelines for competency challenges and emphasizing courts' responsibility to investigate the true motivations behind such petitions. Her ruling protected other elderly people from similar manipulation attempts by family members seeking quick access to inheritance money. The private investigator Thomas Burke expanded his practice to include more estate protection services, helping other attorneys document suspicious behavior by potential inheritance challengers. Eleanor's case had demonstrated the value of advanced preparation and professional documentation in defeating family manipulation schemes. Robert Chen's final victory became a teaching tool at the Charleston School of Law, where professors use Eleanor's will and the subsequent hearing as examples of comprehensive estate planning and effective courtroom strategy. Students learn how proper preparation can turn opponents' schemes into self-defeating mechanisms. 5 years later, I still receive Christmas cards from staff members at the charities Eleanor supported, sharing updates about programs funded by her estate and expressing gratitude for her continuing legacy. These messages provide more satisfaction than any family relationship ever could, proving that her money serves purposes far more meaningful than enabling destructive behavior. The Victorian house where Eleanor and I built our life together remains beautifully maintained, filled with memories of genuine partnership and mutual respect. The rooms where Marcus had tried to document my supposed confusion now serve as my office, where I continue providing legal consultation to clients who value experience and integrity over manipulation and quick fixes. Eleanor's portrait hangs in the front parlor, showing the intelligent, determined woman who outwitted her son's greed through love, expressed as realistic planning rather than enabling sentiment. Visitors often comment on her direct gaze and confident expression, unaware they're looking at someone who planned her own posthumous victory over family betrayal. The garden Eleanor tended has become my primary retirement hobby, and I've expanded her rose collection to include varieties from around the world. Working among flowers she planted provides daily reminders of someone who understood that true growth requires both nurturing and pruning, support and boundaries. When former colleagues visit for dinner, they inevitably ask about the competency hearing and Eleanor's estate planning strategy. These conversations reinforce how impressed legal professionals remain with her comprehensive approach to family protection and charitable legacy preservation. Her reputation has only grown more legendary with time. Marcus's name never comes up in these discussions unless someone specifically asks about family relationships. His absence from my life feels natural rather than tragic, proof that some relationships cause more harm than benefit regardless of legal or blood connections. Eleanor's gift included freedom from toxic family dynamics. The ultimate revenge against Marcus's manipulation wasn't causing him pain or public embarrassment, though both occurred naturally as consequences of his own actions. The real victory was proving that Eleanor's assessment of his character had been completely accurate, and that her love had included the wisdom to protect her legacy from his predictable behavior. Standing in my study surrounded by law books and legal awards accumulated over 4 decades of practice, I often reflect on how Eleanor's strategic planning surpassed anything I might have conceived professionally. Her understanding of human nature, legal procedure, and long-term consequences created a defense more sophisticated than most attorneys could design. Today, at 76, my cognitive function remains sharp enough to continue providing legal consultation while managing Eleanor's estate according to her detailed instructions. The competency evaluation that Marcus intended as my professional destruction instead became comprehensive documentation of mental acuity that exceeds normal expectations for someone half my age. The decorated envelope Marcus never prepared couldn't have contained anything more powerful than Eleanor's will, which turned his greed into charitable good and his manipulation into legal precedent protecting other elderly people from family exploitation. Her final gift was justice served through intelligence rather than emotion. If this story of ultimate preparation defeating family betrayal had you cheering for justice, smash that like button right now. My favorite moment was watching Marcus realize that his mother had anticipated his exact scheme 3 years in advance. What part of Eleanor's planning impressed you most? Drop your thoughts in the comments below. Don't miss more incredible stories of wisdom triumphing over manipulation. Subscribe and hit that notification bell so you never miss an upload.